Our last speaker of the day is Professor Bronfenbrenner.
Thank you, Chair Lieberman, members Becker, Hayes, and Pierce, for giving me the privilege of testifying here today and for the fair and dignified manner in which you've conducted this hearing. My name is Kate Bronfenbrenner. I'm from Cornell University, where I'm the Director of Labor Education Research. I've spent the last 23 years as engaged in scholarly research in the area of labor and management behavior in certification elections in the private and public sector. For the last 2 days, we've heard many voices. Some coming from the employer side were outraged that you would tamper with a system that has served them so well for so many decades. Unions are winning, they say, in NLRB elections. But as the workers who testified here made clear, those numbers only include the fewer than 50,000 workers a year who managed to survive the gauntlets of threats, harassment, intimidation, coercion, retaliation they have to endure first to even get to a petition, much less get to an election or win. We have heard multiple employer representatives state that employers first learn of campaigns after the petition is filed, and if the campaign process were streamlined, they wouldn't have enough time to prepare for their campaign and communicate with their employees. And this lack of communication would have an impact on election turnout that would bias in favor of unions. Last, they repeatedly mentioned that the streamlining proposals, such as giving the union the email addresses, are an unprecedented invasion of privacy. But my past research, along with the NLRB's own documents, as summarized in the study I conducted with my co-author, Torian Warren, say otherwise. As Professor Warren explained earlier, before our research, no one knew exactly when employer campaigns began because they were using the only variable at their disposal, the date unfair labor practices were filed. But by going through the painstaking process of searching through FOIA and NLRB documents for each unfair labor practice allegation in our sample, and since I personally reviewed every single case and document, I can assure you how painstaking that research was. We were able to develop and add a new variable to our already unique data set of ULP allegations occurred. This allowed us to examine the relationship between petition date, election date, and when the most serious employer employer opposition actually occurred during the representation campaign. It also allowed me to, in answer to your earlier question, to make sure that the allegations were indeed election-related allegations and were tied to the specific election that occurred. Our data not only show that nearly half of all serious allegations occur before the petition, but the percentage is the same for serious ULP allegations, 1. And that many occur many, many months before the petition, and for most continue straight up through the elections and beyond. Thus, contrary to employer testimony, for a significant number of employers, opposition starts long before the filing of the petition and continues on after the petition while workers wait for the election to be certified and persists still after that. This mission is accomplished through multiple tactics at the employer disposal. They're the building blocks of employer campaigns that I've seen in my research for the last 20 years. These include threats, interrogation, surveillance, fear, coercion, violence, retaliation, harassment for union activity, promises and bribes, and interference with the election process itself. It is notable that threats, interrogation, and surveillance are especially concentrated before the petition is filed. For example, with 72% of surveillance allegations occurring before the petition filed, it is difficult to take employer concerns about privacy seriously. As for their ability to communicate with employees, they have a host of legal means of communicating with employees, such as captive audience meetings, supervisor one-on-ones, letters, leaflets, videos, and emails that our data show they use early in campaigns. 90% of campaigns that did weekly supervisor meetings 67% that did 5 or more captive audience meetings, and 57% that did 5 or more letters had at least one serious allegation occur 150 days before the election took place. If they can communicate that well before the petition, they should have no trouble communicating afterwards, nor will lessening the delay impact turnout. Turnout has averaged above 85% in NLRB elections regardless of delay because both employers and unions know that every vote matters and they work very hard to get their voters to turn out. But the finding that is most relevant to the issue of timing of elections is this: employer opposition to unions is constant and cumulative. I stand here at the close of the hearing process to reassure you that the streamlining of the election process matters. Timing matters. Not in the way that scholars have usually plugged it into longitudinal equations with outcomes the dependent variable with very mixed results. The time between when the employer campaign starts, when the petition is filed, and when the election is held matters very much to whether workers are able to withstand the intense opposition, both illegal and legal, that the majority of employers routinely engage in today, long enough to file a petition, stay through the election, through the challenges, and then certification. The proposed rule change will be a step closer in ending the process of having workers winnowed out at each stage for no other reason than delay-enabled employer opposition to continue 1 day longer than the workers could bear. Thank you for your patience.
Thank you for your thoughts and being here with us. Other questions?
I want to get a sense of the universe. So the numbers that you were giving us today and that your co-author gave us were from the last year of your study, is that correct? So for example, the 72% surveillance findings pre-petition?
Yes.
And how many elections were studied in that last year?
In the last year, there were 154 elections and 236 ULP allegations out of our full sample of 1,000 elections, of which there were 49% had ULP allegations.
And then the 50% of serious allegations pre-petition and 72% of surveillance pre-petition, those percentages are when the conduct occurred which eventually led to a finding, or when the conduct occurred which eventually led to a charge?
Those are 47% of, well, it's both. 47% of where charges were, 47% of charges that were filed, but we also found 47% of charges that were won either with a settlement or a board or court win.
Thank you.
Anything else? Well, we thank you very much for sharing your research with us.
Thank you.
And that, I suppose, concludes our second day. We thank all of you who have stayed with us till the end for being here. We thank all of the speakers for your thoughtful contributions. As I said at the beginning, we take this meeting very seriously. We have open minds. It has been most interesting, I think, for all of us to hear the diversity of viewpoint, the diversity of experience. I think you have made this rulemaking much richer. We look forward to seeing all of your written comments. As I said at the beginning, my colleagues, once they read any written testimony that you may submit with us today, may have some further follow-up questions. We'll endeavor to have those to you if we have any within a week. You have until August 27 to file any responses. But we do thank you very, very much for being here with us. Do my colleagues have any closing comments? No? Well then, I guess we stand in recess, and again, thank you for being with us. I know a lot of you came a long way.